125? It's high up. One false move, boom, 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 ejected from the car, crack your cranium, dead. Oh,
Stop.
no. If I find that you drive, I will have a contempt hearing. You'll be facing 6 months in jail and a $500 fine every time you get into a car and drive. You roll your eyes like that again, I'll hold you in contempt. Mr. Gary, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. You cannot afford a lawyer be appointed to represent you, sir. Please don't say anything. Okay.
Thank you, Your Honor. On May 27th, 2024, officers caught into a vehicle that speeds 125 miles per hour.
125?
And the vehicle was still creating distance between the officer and the patrol car. It was very traffic. It was heavy traffic at the time in Harris County. While trying to close the gap between the patrol car and the speeding vehicle, the officer observed the vehicle change lanes in an unsafe manner several times, causing other vehicles to slam on their brakes to avoid striking the speeding vehicle. And the vehicle also did not signal its lane changes. Officers were able to catch up with the vehicle after maxing out the patrol car at its top speed of 135 miles per hour. The vehicle immediately took the exit for Airtex Road and pulled into a Stripes gas station parking lot. The defendant was identified as the driver.
What kind of car was he driving?
Truck. I remember.
A pickup truck, Your Honor. A silver 2009 Chevy Silverado.
I'm going to find probable cause, Mr. Garrett. Do you realize that it's high up. One false move, boom, 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 ejected from the car, crack your cranium, dead. I'm now taking away your privilege to drive, sir. You're not allowed to drive at all. You're going to sign with me today an affidavit promising me you're not going to drive. I don't care what's going on in your life. If you drive, I will have a contempt hearing. Oh,
Stop.
no. If I find that you drive, I will have a contempt hearing. You'll be facing 6 months in jail and a $500 fine every time you get into a car and drive. You roll your eyes like that again, I'll hold you in contempt. It shows a complete lack of respect. All I want is public safety. That's all I care about. Every single day, someone dies on the road in Harris County because of some boneheaded move. Not here, not today, not anymore. You understand? If you drove here, you may not drive home. Do you understand?
I don't get to work. I don't go to work no more.
I didn't tell you you can't work. I just said you can't drive.
I'm a business owner. That's how I make it work. My vehicle gets me to work, sir.
All right, dude. That's it.
I didn't ask for an apology. I said, how do I get to work? How am I going to
Take
get
an
to
Uber.
work?
You can find someone else to take you.
Both pool tables. Can't put a pool table in the back of an Uber. I'm just asking. So I'm trying to. I'm
You're gonna have to hire
just trying
someone
to
for you.
continue to be a citizen and keep my job, right? That's all.
You can't fool the judge. There are many ways to get to work without driving. Saying sorry won't fix it. If the judge lets you drive again, dude, you'll just speed and endanger someone's life or your own. Maybe not today, but in a week or a month, you'll do it again. You need to be punished so that you don't do it again.
That's all. That seems a bit much, right? For somebody, I understand. You're a judge. I'm just trying to make my plea. You know, I have to work. That's all. I'm just trying to continue my job. That's it.
But let me tell you something, Mr.
Just trying to continue my job, man. That's it.
The ability to drive is a privilege.
I understand. So I've been in the system long enough to understand what your job is. I just have a job, sir. That's all. I'm sorry. I apologize. I don't want to be here. You know what I mean? I made a mistake. I got a job, right? Just I got people that work around. I got people to depend on. I make mistakes, and I apologize. And
I want to see that you truly mean it. I don't know that now. I don't know
it's
it.
fine.
For right now, I'm taking you away your privilege to drive because I want you to appreciate the awesome privilege it is to drive at 135 miles an hour on the road in what, a 65?
I assume so, Your Honor, it was approved.
You're going double. I'm gonna have you sign this affidavit with me. We're gonna reset your case to give you time to hire a lawyer. When you come back, we can talk about it, but I want you to really appreciate it. And I want you to show me how much you appreciate it. But until that point, if I find that you drive, I will have a contempt hearing. You'll be facing 6 months in jail and a $500 fine every time you drive. Do you understand? I'm gonna have you sign the affidavit. We'll have you sign a receipt and we'll get you out of here. We'll see you in a month. She has an open case upstairs that's also in warrant status.
In this case, this defendant is a mom, and he gets involved in an argument in an apartment complex to defend her child. During the incident, she sprays pepper spray on a 15-year-old and another person. The defendant has a history of domestic violence and assault charges.
Frank has been talking with Judge Nelson in the
Is this, may I have the case number, please?
252 1200.
Child salon tree. Okay.
So because she has a felony warrant, I'm not going to release her. We'll do PC now, and I'm going to keep her, and then Frank's going to run up to the 482nd to try to get her a bond set there.
It looks like probable cause was found on July 25th, Judge.
I'd like to know, but I don't know. All I know is that she's charged with assault. She also has an injury to a child. It looks like they're out of the same transaction.
Yes, Judge.
You're facing up to a year in jail and or a $4,000 fine in the assault. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you then.
On June 24, 2024, officer with multiple complainants, and one of the complainant's mother, Dr. Complainant, in this case, investigated an assault that occurred in an apartment complex. Complaint stated that on Wednesday, June 5th, 2024, this complainant, that's sort of part A, the complaint that they met, the brother is a complainant in this offense who's 15, and his friends were walking their dog and found a juvenile male who's the son of the defendant over problems they had in school. Juvenile male's mother, the defendant, exited her apartment unit, started to confront the complainant and followed co-complainant and this complainant to a fence. The other complainant felt the need to defend himself due to the now defendant being close to him, but he did not assault the defendant. Defendant pepper sprayed that defendant and that complainant, this complainant, attempting to get her to stop by swinging at her. Defendant also pepper sprayed, pepper sprayed this complainant, but only hit one of his arm. The other complainant felt pain from being pepper sprayed by the now defendant, and the first complainant, the mother of the other complainant, wanted to pursue charges. A witness who lived in the apartment complex corroborated the statements of all the complainants.
So who are the complainants now?
So
Relation?
it is brother complainants and their mom, who is another complainant, but I don't know if they.
So it's familial.
I think it's the two boys, the complainants, but one of them's 15 and older.
So they wrote it as complainants, but it only accepted charges. So I guess the way they verbalized it initially to the officers, the way they wrote it down was complainant 1, 2, and 3, or
Okay.
complainant 2, mother, complainant 1. So formally, in terms of the charges, there is the complainant upstairs for injury to child, and then this complainant is 15, which is why it's right above the felony level. But they wrote the mother as complainant, I guess, to the surface.
Ours is
But the complainant here is a 15-year-old.
no familial relation.
None.
No, it's just that their brothers and friends encountered the juvenile male, the son of the now defendant, over problems they had in school. So it seems like there was a schoolmate issue.
Okay. Ma'am, did you want to say something? I'm sorry.
I mean, I know that we'll fight the facts in the future, but she takes care of 3 children. The son that they're talking about, the son's 12 years old. Looks like there was some argument between these kids, and just to make her point of view, she was trying to speak with the complaining witness's mother regarding this whole situation. Looks like it got out of hand. I do have a picture from the defendant regarding an injury that she received from a busted lip of that day from the juvenile. Moving forward, I would like to set a bond, at least at the minimum of $1,000, and it'd be a PR bond. Judge.
Great state of Texas.
Judge, I just need seconds. I was trying to look up something else that wasn't popping up. Your Honor, state requests that reasonable bail be set because this is not the only complainant involved. Obviously, there's the felony as well, and the fact that she has been charged prior for a disorderly conduct with a deadly weapon, assault family member.
The injury to a child, it's what, 14, right? 14 and under?
Yes, and the other complainant was 12. So that's why there's a felony and a misdemeanor, and the fact that there's involved and there was a witness is that allegation still continues on, and so state requests reasonable bail be set at 7,500.
Family violence was dismissed, Judge. The only conviction I see is theft.
Yeah, I mean, I see two dismissed, I see dismissed it orderly. Do you have any like out of state or anything else?
Fine. I'll run the, I don't believe it's,
Okay, well,
it's not enough for me to impact my,
right.
oh no, it's not, never mind, sorry, they're all in, but
So it looks like the only possible conviction that I see is a theft from '09.
yes, Judge.
And the other two cases,
The only bond forfeiture is very,
okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm going to set your bond at $1,000 now. We'll give you a PR bond now, but I'm not going to play this game. I'm going to protect everyone in my community at all costs. I don't care who you are, where you come from, doesn't matter. You understand? As part of your bond conditions, you're not to have any contact with the complaining witness in this case and not to be in possession of any weapons as well. Weapons is a very loose term. So if you have any questions, talk to Frank because no weapons whatsoever. I'm also ordering you not to go where they live or where they work as well, man.
I do have a concern about that because do they live in the same apartment complex or is it a different?
I think it was the children that are schoolmates, so I don't think there's otherwise, but not that I could find. I'll take a closer.
They were just roaming around.
Her head, so I don't believe that'll be an issue.
And so you're okay. I'm going to attach you to this as well. I'm going to go ahead and email Judge Nelson.
This is the ADA on record. I'm just helping out since we're shorthanded and but I'm not opposed.
Okay, I have emailed you guys and I CC'd you guys. I've also talked to her. Would you please take a seat in the jury box? Do not leave until we have you sign bond conditions and then until Frank gets back to talk about the bond. Okay?
Thank you, Judge.
Rodriguez?
No, ma'am. Jury box.